Welcome. This is Bonnie Sewell, owner of American Capital Planning, a fee-only fiduciary and female-owned wealth management firm with a specialty in divorce financial planning. Thanks for joining us with our poolside chat today. If you were here last month and since January, you know that these were fireside chats. But hey, it's May. Let's make them poolside chats until the end of October when it turns cold again. So I just wanted to say hello from behind the screen, let you know who's doing the talking today. And we are going to dive in to our topic today, estate planning. I'm going to turn my video off, and I hope you enjoy the topic and the presentation and the slides. So again, welcome to the May through October version of our fireside chats, the poolside chat. I wish we were talking about something a wee bit lighter than death and disability today, but actually, I think it's best to cover this when it isn't acute, simply because a grief process can overwhelm us. The idea is to prepare as thoroughly as possible for the risks we face so that a tough situation goes as well as it possibly can. On this subject, there is a lot of jargon and legal terms specific to your state and to your documents. We are talking for just under an hour today, and it would be impossible in that time to cover everything. So with this disclaimer, see my air quotes, this webinar is for information only. It does not provide legal, financial, or tax advice. The content shared is the opinion of the speaker alone and does not reflect the views of anyone else, close quote. And we'll do our best, as I said, to keep that jargon to a minimum to enhance your understanding of how to use the tools and processes we're going to cover in your own estate plan. So let's dive in. As you can see, this is a visual of how big this topic is. This is the elements chart, or like a periodic chart just for estate planning. As part of our planning process, we recommend that everyone walk through the valley of death, as it were, so that you are as prepared as possible and to ease the burden on your family and loved ones to the degree that you can. We often attend these planning meetings with our clients so that their final plans work in concert with their financial plans. And by putting this slide up first, I want to make sure you hear me say these cover everything that, for the most part, that can come up at all in an estate plan, which for many people, it's going to be much simpler, and that's fine. We want to help you understand what your needs are depending on where you are in your financial life. So let's start with a will. The will is an important document. More than half of all American adults don't have a will, and many times when people come to us as a client, they don't have a will. A will determines where your assets that are outside of a trust or a beneficiary statement, if they don't have beneficiaries, it says how they will be distributed. So that could be your home, your car, your bank accounts, or your personal possessions. To make a will in the US, you have to be of sound mind. You have to be able to name your property and beneficiaries. You have to sign the will and have it witnessed by two people. Think of a will as a little bit of a sweeper document. It cleans up and transfers the things that are not already transferred through a separate process like a direct beneficiary. A will cannot transfer property that you hold jointly or with someone else. It cannot transfer property in a living trust. It cannot transfer anything with a named beneficiary. It cannot transfer any property or account held as transfer on death or payable on death. So I'm going to repeat this a couple times during the presentation. Some of what we're talking about may raise more questions than you had before you started listening. So please write them down or ask us at the end of the webinar. And send the ones that you write down to us, and we'll get answers for you. We don't recommend leaving funeral service instructions inside a will, since wills are often read days and weeks after death. Too late to figure out you wanted some sort of burial service instead of cremation, for example. assets in a blended family. So we do a lot of divorce work. A lot of people get remarried, and then we have a blended family. Those may not end up being distributed the way you would like if you don't have a will. If you're incapacitated but not killed off, the choices made about your medical care may not be those that you would want. If you die without a will, you're still making a decision, and that decision is that state law will determine who gets your assets. Make no assumptions about how things transfer to people or organizations that you care about. Find out. A living trust serves two purposes. It allows you to pass on assets without going through the public probate process, and it allows someone else to manage your affairs if you become incapacitated. Your trust can own your house, your car, your bank accounts, and other assets. You can make yourself trustee, but you can also appoint someone called a successor trustee who takes over if you die or can't manage your own affairs. For example, if you're in the same car accident. While you're alive, it's essentially an extension of you as a person. Living trusts do have a downside. Compared to wills, living trusts are considerably more time-consuming to establish, involve more ongoing maintenance, and are more trouble to modify. A lawyer-drafted trust will cost upwards of $1,000, and they often make sense for larger estates and those who are likely to die within the next 10 years. For example, if you have a diagnosis that doesn't look good. This is why we work with ethical and knowledgeable estate planning attorneys. Living trusts are indeed oversold, so if you go this route, just confirm that you actually need it and that a will would not suffice. So for comparing living trusts and wills, here's a kind of a quick comparison to think about. Revocable living trusts, so that means I can take it back. I can take back what I said in that living trust while I'm alive. Irrevocable would be the opposite, obviously. We'll talk a little bit about those in a few minutes. Both revocable living trusts and wills can name beneficiaries for property. Leaving property to young children, we can do that in a living trust. Sometimes we can do it in a will. We can revise either document. So revisions are not difficult with either document. As we said, sometimes it costs a little bit more if you've got a trust. But a trust can avoid probate, which we'll talk about and define in a few minutes. Just remember, it might be good to avoid probate. A will can't do that. A trust can keep your privacy after death. It requires a notary republic. It requires a transfer of property, and it gives you some protection from court challenges. A will does not do any of those things. A trust does not name guardians for children, but a will can. A trust does not name property managers for children's property, but a will can. A trust does not name an executor, but a will does. And a trust does not instruct how taxes and debts should be paid. A will does. A trust is a little bit more complicated. A will can be simple. A trust does not require witnesses. A will does. So those are some of the comparisons between the two. But of course, as we said, you're going to get great professional help so that you don't have to know all of this yourself. We're just trying to make sure you think about these things, or your advisor thinks about these things when you go to get these papers done. So let's go to the next piece that's important to so many parents: guardianship for minor children. Who will raise your children if both parents are deceased? This is an opportunity to plan for children's health and well-being and their education. It's also important to plan for how any life insurance payouts and money you leave to your children will be handled for their benefit. You can set the ages at which different monetary amounts will be distributed. Remember, not doing this is still making a decision, and the state will decide who will raise your children, which affects where they will be educated, live, and any religious or lack of doctrine that they live under in a new household. So for most parents that we talk to, they would prefer to make those decisions, even if they're imperfect, rather than having the state, who does not know or love your children, make those decisions on your behalf when you're gone. There's also sometimes a useful tool called a special needs trust. These provide for a loved one with a disability without jeopardizing social services and government benefits. So let me say that again. Sometimes we have family members that we would leave things to once we're gone. But sometimes those family members are part of our social service system and benefit from the way things are set up while we're alive, because they get some social services and then we pay their bills while we're alive. If we go, we want things set up in a smart way that preserves those social services for them and lets them have the benefit of our money and assets in our absence. So again, see your attorney to discuss this if this would solve an issue for you. The executor. When you draw up your will, you need to choose someone who will carry out your wishes, and it's a good idea to get their agreement to do so. A simple estate might be able to be handled by a friend or a relative with the help of an estate lawyer, but a more complex estate may require professional management, something you'd want to set up. An executor is held to the highest degree of honesty, impartiality, and diligence. It's an honor and a burden, since it's immediate and there can be many duties required of them. Here's some of the things a typical executor might handle. They're going to find the deceased person's assets and manage them until they are distributed to the inheritors. This could involve deciding whether to sell real estate or securities owned by the deceased person. They're going to decide whether or not probate court proceedings are needed. Most jointly owned assets pass to the surviving owner without probate. But if you don't have a surviving owner, you might have probate. An executor is going to figure out who inherits the property if the deceased person left a will. And then they're going to file the will, if there is one, in the local probate court. Generally, this step is required by law, even if no probate proceeding will be necessary, because they're going to get another set of eyes on it. An executor will handle day-to-day details, and this is where a lot of things can get very time-consuming quickly. This might include terminating leases, credit cards, notifying banks, government agencies like Social Security, Post Office, Medicare, Department of Veterans Affairs of the death. This can take hours and days to resolve, sometimes physical visits to these places and to complete. An executor will set up an estate bank account. This account will hold money that is owed to the deceased person. For example, paychecks or stock dividends, but obviously if that person isn't there to endorse them, they're going to have to go through this process. An executor will use estate funds to pay continuing expenses. The executor may need to pay, for example, utility bills, mortgage payments, and homeowners insurance premiums. The executor will pay debts. If there's a probate proceeding, the executor must officially notify creditors that that's going on and then follow the procedure set out by state law. The executor is going to pay your taxes in your absence. A final income tax return must be filed, covering the period from the beginning of the tax year to the date of the death. State and federal tax returns are required only for large estates, but personal ones will generally still be filed. An executor will also supervise the distribution of the deceased person's property. So the property will go to the people or organizations named in the will or those entitled to inherit under state law, such as a beneficiary, but they have to look after that process. It's our opinion that in the majority of cases, an executor should be paid for their time to meet their duties. You can provide for this payment right inside your estate documents. And we're talking a small percentage of the total estate, but it can be very helpful. A durable medical power of attorney. This is an important part of estate planning. It allows you to name someone to make medical decisions for you if you are unable to make them yourself. Now, in this situation, you have not died yet. If they know your wishes, they're supposed to act consistently with them. And if they don't, they're supposed to act in your best interest. You can imagine, depending on the medical or health issue, how harrowing this can quickly become. Choose your person carefully. Not choosing means that the doctors will make the decision and they may not even be your doctors. For example, if you have some medical issue where you are not cognizant to make your own decisions while you're traveling. I'll let you read this comic strip for a minute. As you can see, they're making a joke about being unplugged. And in this case, this gentleman apparently is, his life is supported by his television. So her idea of unplugging him was to take away the television. I think that's a great lighthearted way to start to have this conversation about a living will, something we also call an advance directive. A living will is a document that provides direction to your loved ones, family members, and the physicians that you're going to deal with regarding your preferences for end-of-life care should you become incapacitated. But it does not appoint anyone to make your health care decisions. Your living will can specifically address medical possibilities, such as whether you want artificial respiration, nutrition, or hydration withheld, as well as what types of pain medications to allow, and whether you prefer to live your last days at home or in the hospital. So we're not doing, surgery decisions or independent medical decisions, which is what the durable medical power of attorney would have covered. We're talking about end-of-life care and your preferences. If you become incapacitated, your physicians and loved ones will look to this living will for guidance. Think of it as a gift to those you love who will be asked to share your guidance as they are grieving. But it's not all medical. Now we've got things to do financially while we're having some event medical go on. So this allows someone to legally manage your financial affairs. You can limit it to certain functions, or you can make it all encompassing. Some things you might want to have this durable financial power of attorney do in your incapacitated absence is use your assets to pay your everyday expenses and those of your family. Buy, sell, maintain, pay taxes on, and more real estate and mortgage. Pay your mortgage on your real estate and other property. You might have them collect Social Security, Medicare, or other government benefits. You might let them invest your money in stocks, bonds, and mutual funds if this is supposed to be a prolonged period. You also might want to have them handle transactions with your banks and other financial institutions. Maybe they're going to be buying and selling insurance policies or annuities for you. Maybe they're going to file and pay your taxes. Remember, in this situation, you're coming back. You just need someone to keep things going. Maybe they're even going to operate your small business or claim property that you inherit while they're incapacitated or otherwise are entitled to. Maybe they're going to transfer property to a trust you've already created. And maybe they're going to hire someone to represent you in court and manage your retirement accounts. The agent who is your durable financial power of attorney is required to act in your best interests, maintain accurate records, keep your property separate from his or hers, and avoid conflicts of interest. So that's a lot to do. So again, your choice of who you're going to have do these things is really important, but it's not forever. You're allowed to go back and change these choices as you see fit or as your needs change. You just need to do it through your attorney so it gets done correctly. Tax planning and dealing with probate. The new tax law that was passed at the end of 2018 raised the estate tax exemption, or the amount that you can have in your estate before you start getting taxed, to 11.2 million for single people and 22.4 million for couples. Now, this law does sunset. Some of the tax reform stuff was made permanent, but this was not. So this will go away again on January 1, 2026, and it'll revert to the pre-2019 levels. And the reason that that's so important is because if you're not planning on dying before 2026, but you might fall into the old amounts, which were quite a bit lower, you and your attorney need to plan for when this thing sunsets. So that's kind of a hassle potentially for some families, but even then it was over 5 million. So it's probably not going to affect too many people, but if it affects you, you sure want to know about it. And 13 states, including DC, Washington, DC, have state estate taxes, while 6 states have an inheritance tax. So that's 3 layers there for where it applies, right? Our federal estate tax, 13 states plus DC have state estate tax, and then some 6 states have an inheritance tax for your heirs or the people who would get your property. So below we've listed each state. I don't have them on the slide that charges estate taxes and the amount of the state tax exemption. So that's something we can say to you or send to you easily, but I will say that Maryland has a state estate tax, and District of Columbia does, Virginia does not. So depending on where you live, you may want to have that information as well. So let's say that even with this, you owe estate taxes. What would you do about that? Or you think that you're going to live past 2026 and for sure you'll owe them then, if that's true for you. Well, one way to resolve that issue is you can set up an ILIT, or Irrevocable Life Insurance Trust, ILIT, I-L-I-T. And that can be set up to help your surviving heirs pay any estate taxes that you have. But whenever we put irrevocable in front of a trust, that means that it's gone out of your estate, you don't control the asset anymore. The trust is going to be the owner, and the trust pays for that insurance policy. So you die, the proceeds from the insurance policy go into this irrevocable trust, and your estate planning attorney can help your heirs and so forth pay those taxes. So that's one way to solve that issue. But one goal of estate planning is to manage the court system's probate process. So we've been using that word, and we're going to define it here. This is the formal process that lays out the distribution of all the stuff you own. It involves all the big stuff. We'll get to the little stuff in a minute. It involves determining the validity of your will. Was the person of sound mind? Is it signed? Did it get witnessed? Is it dated? It documents the property that you have to distribute. It makes sure your taxes and other debts get paid. And then it physically distributes the assets under your will or under state law through that beneficiary process. Your attorney can explain your state's probate code because they are different. Some are really complex, like California and Ohio, where a lot of planning really needs to be done. And some are simpler, like Texas and Georgia. You still want to do some planning, but it'll be much easier. 20 states have adopted something called the Uniform Probate Code, so they all look alike. And many states have a simpler process for smaller estates to avoid probate altogether. So that's important to know, because if you're assuming that you've got all this planning to do, but you're only going to end up with a small amount of money almost under any case, your state may well have a simple process for your heirs and your executor to go through without the bigger hassle of the big process. Even in death, we're going to file a final tax return. For the less wealthy, remember that your heirs will have to file your income tax return, so make sure they can find that information. Beneficiaries. We are naming a person or organization to receive an asset when we die. So if I want my retirement account to go to my nephew, it goes, I name the nephew as the beneficiary, and it doesn't have to be brought up in my will. Just as soon as I die, that retirement account gets distributed over to that beneficiary because I named them on the account. There can be restrictions on who you choose for a beneficiary. For example, if you have an ERISA plan or a company retirement plan like 401k or a pension plan, the spouse always receives those assets automatically unless he or she has signed a spousal waiver or an estate or trust is named. So there's a few ways we can have this one kind of asset not go to our spouse. Maybe our spouse is independently wealthy. Maybe it's a second marriage and we want those accounts to go to our children from a first marriage. There's a lot of things to know about beneficiaries and the accounts they apply to, but the reason that I'm bringing this up to you is for you to consider you cannot just simply name someone else the beneficiary of some kinds of retirement accounts like 401ks, 403bs, other ERISA regulated plans. On those accounts, the spouse is always the beneficiary unless they sign off on date, and that signature is real, that they acknowledge that they are not going to receive that account. When we name a beneficiary and we die, they receive the asset directly versus going back through the will or probate. That's the benefit of having a beneficiary named on accounts. It's important to keep these current, or people that you might not want to receive your accounts may get them. For example, an ex-spouse, for example. So just keep that in mind because that happens actually much more frequently than I think most people appreciate. You're also going to want to name contingent beneficiaries. That's just what it sounds like. If the first name beneficiary is not alive or able to receive the asset, it would go to the contingently named beneficiaries. So let's say there's an airplane crash, God forbid, and there's more than one family member on that, and they've included both the person who died and then their first beneficiary. Contingent beneficiaries, assuming they were not in that same situation, are who the asset would go to. How you hold assets. Now we're talking about something as dull as titling here. And most of us, when we buy a home or property, we just sign the papers. We understand the math. We've done a lot of other good work, but we're not giving a lot of thought to how that is held in terms of title. So sometimes we make assumptions about our own property. Do you know how title is held, for example, on your home? Some joint assets automatically pass to the surviving partner, which doesn't have to be a spouse in this case, upon death. But we can also own real estate with one or more other co-owners as tenants in common. If I die and I'm a tenant in common, I can pass my interest to another person through my will. A downside of this is if I don't die, but you do, and we were co-owners, and you passed your interest on to your cousin Fred in Alaska, who I don't know or like. So understanding the possibilities around something like tenants in common, okay, I don't have to give it to a spouse. I can choose who I want to give it to. There can be co-owners. There's some interesting possibilities there, but you want to make sure you've looked at the upside and the downside. And then there's tenants by the entirety. And by contrast, that can only be used with owners who are legally married. So if you and I want to own property, but we're not married to each other, we can't do tenants by entirety. We could do tenants in common or some others, but we can't do that one. So I want you to discuss the options with your attorney to make sure you're holding title to homes, bank accounts, and other possessions in the way that will benefit you. And I can just tell you one quick thing that we do see in the office that can be a little bit of a frustration. Sometimes we see people put things into trusts and it's done on the advice of their attorney, but their attorney hasn't looked at their financial plan. And so we've missed an opportunity there to marry those two things, as far as them talking to each other and not being in conflict should something happen. And then the second time it can be a little frustrating is, let's say, for example, you want to hold your home in a trust, and you've done that for good reasons, and you're happy with that arrangement. But you fail to retitle other things that affect your house, like the homeowner's insurance and the umbrella policy. If you have your home in trust, but you don't retitle your insurances tied to that home in the same exact words of the trust as the trust, we can run into problems if we have a claim. Because if I'm an insurance company and you're making a claim on your home, and I go to the policy and I see just your address and your names, but no trust name, and then I go to pay on that property, pay the claim, and I realize it's in a trust, I'm going to tell you that I can't do that easily, because it looks like I'm dealing with two different properties. So just, there's some simple things that get overlooked when we don't marry our estate plan to our financial plan. So I want you to be thinking about that and asking your attorney to think about that, so that all the T's get crossed and the I's get dotted, and no one gets surprised unpleasantly if we are holding an asset in a particular way but haven't attended to the other details with it. Whoops, gonna go back. Digital and special assets. To ensure your personal, financial, and business accounts, you need to address access to these, so that's passwords, logins, in your estate plan. And if you're like me, I try to be as organized as I can with those. Sometimes for clients, we even have a password index. It's not, and you can imagine how quickly that gets out of date, right? When they did the original paperwork, these were their passwords. But just like you and me, every once in a while, they get told by the people that hold those accounts, it's time to change your password. And they forget all the other places the password is, and they don't let all those other people know. And there are some solutions out there. They're not, in my opinion, just wonderful yet, but they'll get there. We'll have technology solutions for all of this eventually. But until we do, I'm going to suggest to you that you figure out what works for you in terms of a way to hold your passwords. And it could be, one password unlocks everything, because you've gone through a program to do that. It's not just your name backwards with a couple of numbers or something like that. But and it's also the login name or email that we're using plus the password. So digital assets are becoming much more important, because here's another thing that can happen, and I think we're all aware of these stories, or maybe it's even happened to you. Someone passes and their Facebook page is not taken down or attended to in a reasonable amount of time, because the family is really, frankly, concerned with their grief and not Facebook. But it can present problems in a number of ways, and to avoid that happening, we want to set up a procedure for, if so-and-so passes, here's what happens to their Facebook, Instagram, LinkedIn, Twitter, whatever social media they are using, so that can be protected for them as well. That's just something that is still being developed, but there are ways to do it mechanically now, and we're suggesting that you should spend a little bit of time thinking about that and providing that information for someone. And by the way, it's, so if someone were to come into my life and try to get my passwords, and the only place they show up is electronically on my computer, they're going to have a problem, because they first have to get through the security on my computer. Yours may be set up the same way. Phones, same thing. Sometimes phones do a lot of our transacting today. So phones is another place where we want to, believe it or not, include that information in our estate planning. So don't overlook that, please. And then there are what we call special assets. And you can tell by the pictures here that we're really talking about pets. So if my one client who adores cats is listening, she's provided in her estate for her cats. And I'm thrilled she's done that, because they're important to her. And so she's taken the time to think thoughtfully about what that means. And when her cats go, then the organizations that help them will get some of her assets. So pets need immediate care, obviously. Who takes care of our sweet little puppy here on the screen if something happens to you? And then who takes care of them ultimately when things get finally decided? Some people have wine collections. And we're not talking about 300 bottles in your basement because you just, like Total Wine a lot. We're really talking about something that's been appraised, has value, and can be sold or given away to someone that you care about through the process of your estate plan. And then jewelry is another emotional item, not to suggest that wine and puppies aren't emotional, they are, but jewelry is very personal many times, and many times been handed down through more than one generation. So here's a great opportunity to name who gets what, and so things don't go missing. So you have a list of what's in the estate, its approximate value, and who it's going to go to, and where they might find that. Excuse me. And then gun collections, believe it or not, are a very popular thing that we see. And gun collections can be in something called a gun trust. So I'm not going to spend a lot of time on this, but guns have value to many estates, and especially if they're historical in some way. So if that applies to you, just know that that's another thing that we want to address in our estate planning. And this last picture I have on the top left there is Grandma's yellow pie plate. There's an old book called Who Gets Grandma's Yellow Pie Plate? I can't recommend the book because it's just out of date and it's not that great, but I thought it was a clever name because it conveys what I'm trying to get you to consider. If when we think about Grandma, we remember her amazing pies and the pie plates on which she served those pies to us, then this inexpensive yet very valuable personal item could easily be dealt with in our estate plan. And one of the simplest ways to address this kind of personal property, I think your lawyers will agree, is that don't have a lot of value, just a lot of emotional value, is a personal letter dated, signed on top of your will. So that's an easy way to not have fights. An expensive way to dissipate an estate unnecessarily is to not address things that have high emotional value, but your heirs will fight over them. So something, your family best, so think about how that would work for you. And then again, an option you can ask your attorney about is called a purpose trust. And it is to hold exactly the kinds of things you see here on the screen. But purpose trusts can be highly regulated to make sure that your wishes actually get carried out. So just, again, we're giving you ideas and things to talk about with your attorney so your estate plan is complete. Excuse me. This is a picture of our electronic vault that all of our clients have access to. It's a personal vault for each of them with no size limits. They can put their entire electronic life in here if they so desired. No one's done it yet, but we do see a lot of clients using this valuable resource to have secure files in a place that they can access from anywhere in the world. So if you're not a client currently, there are other versions of this out there. And again, just having your password to get into them is pretty key. But where to keep your plan and the things that matter to your plan, we have quick access, or you can share with anyone. So one of the things you can see here on the right of the screen is the ability to share these files. So we have had people when they're traveling around the world, have something go wrong at their primary home here back in the States. Everybody needs the insurance file. We've got it. All they need to do is dial into our system. They pick up the insurance policy, shoot it over to their agent and say, this is what's going on, or shoot it to an adjuster, someone who might not be in the system of their insurance company that can easily access that. So that's just one example. There are lots of them. Also, the attorney who prepares your will keep a signed and witnessed copy, but this is another opportunity here in a secure vault online. You can do the same thing. A lot of people used to keep these kinds of documents, stock certificates, which of course is an old-fashioned way we used to keep stock. There are some still around. But those kinds of documents people used to keep in a safe deposit box. And some of you listening may not even know what that means. It was a box down at your local bank. You had a key. It's behind a vault. One of the challenges around a safe deposit box, because we do know people who still use them, Your heirs might not be able to get to them immediately. Electronic secure vaults like the one we're showing on screen are becoming the default choice because there's no access issues as long as you're able to get in or your heirs are able to get in, because as you know, we talked about earlier, they have those passwords and logins, so they can get in here and see this. They can get a copy of your will quickly. They can get a copy of your insurance quickly. They can see for themselves what the investments are, and they don't have to rely on immediate access to the advisor, for example. So these documents, when they're electronic, are easily viewable, shareable, and multiple versions can be stored as you review and revise them over the years. So that's just a really potentially important way to store these documents. I want to go back and just highlight one other thing, house deeds. One of the things that gets lost for people fairly easily is the stuff around their house. So let's just set up one example of the way things can go that's kind of new to the people that are tasked with closing up the person's estate, but are something very solvable. So grandma dies, she's got her house, she lived in her house for 20, 30 years, and it's gained a lot of value in the time that grandma owned it. So she kept her deed in this electronic vault. Grandma's pretty swift with all this new technology. And the good news about that is no one has to figure out where the deed is, right? So grandma has owned her house free and clear for a while. And yes, it's recorded down at the county office, but here they can get the actual deed. The deed gives a lot of information. They're free to sell the house. And the other thing that's in this deed file for most of our clients are receipts and big ticket items where they've improved the house, because in the example we're giving, grandma's house has gone up a lot in value. So grandma paid $100,000 for her account, for her house, 25 years ago, and today it's worth $600,000. Now, if we were to sell that house, grandma might have some tax due on it because she's got quite a bit more than the $250,000 floor, because she's a single grandma, before taxes hit. But if grandma was careful with her receipts, which she was, because she was up on all sorts of things, not just technology, she has a file full of receipts that show that she added more than $400,000 worth of value to that house. She put in a pool and a kitchen and all that good stuff. And so grandma's taxes just went down, or the taxes that her estate will face. So lots of good things to do here. And we just want you to think thoughtfully about all the ways that you can use these tools and keep your estate plan married to your financial plan. A lot of questions we get are, how often should I review my estate plan, and what makes me think that a review should happen if it hasn't been that, if not that much time has passed? Because just like a financial plan can be out of date fairly quickly, especially if an event happens shortly after you put the plan together. That's why we call our plans living documents and navigational, because they're navigating our future. They're not, this is what's going to happen in January 2060, and that's just there in stone. It's not like that. Estate plans are the same way. Normally, we would suggest every 3 years, take a look at it, sit down with us and go over it and make sure everything's kosher the way you want it, and the people that are named are the people you want named. But if there's a triggering life or financial event, so let's say there's a new child in the family, or a new heir, or grandchild, nephew, or niece that changes how things should be arranged, or a new illness that requires a change in healthcare or medical directive instructions, right? So you want those to be as current as they can be. Divorce or death of your spouse would change an estate plan. If you move to a new state or a new residency with a second home, so let's say I used to be a Chicagoan, now I'm going to be a Floridian, and now my new domicile, as our tax laws like to call it, is Florida, not Chicago. I still have my Chicago house. It's just that I spend 6 months and a day down in Florida. Well, now I'm a Florida resident. My will should reflect that change. And same thing if I move to a new state because my spouse took a new job or whatever. Remarriage is a time to get your estate plan reviewed and changed. A material change in your assets or debts, right? You can just think about that for a second and see how that could be true. Maybe I win the lottery. Maybe I inherit money that needs to stay on my side of the family and go to my heirs individually and not blend it with something else. Maybe I just want to make a beneficiary change, and I can make that for any reason. Maybe I want to add a charitable legacy, some organization I want to give things to. Or let's say the lovely people that I've named in my estate plan through executor or beneficiaries or trustees have died or have become incapacitated in some way, can no longer carry out the functions that I need. So those are just some, excuse me, of the reasons we might revisit an estate plan sooner than 3 years. So that's a quick look at estate planning and all of the things that we think about when we sit down with clients and we're trying to figure out what do we need to be looking at here and what are the T's we need to cross, I's we need to dot in terms of your financial planning and your estate plan. Those two things should always be in concert. And when they're out of sync with each other, the risk we run is that someone has an event and we have not just hassles with getting things done, there's potential for litigation, which is the last thing anyone wants when we've had a death or disability situation. So I'm going to stop there and see if there are questions, and I'm going to open my little Q&A box here and see what we've got. And I do have one question here. The question is, can we recommend an estate planning attorney? Yes, and we have several, and we always try to give at least 3 names. One of the things I would say to you when we're making a recommendation for any other professional, but in particular estate planning attorney, we are trying to assess who would be a good fit with what we know about your situation and what we know about you. If you're particularly haunted by having these kinds of conversations because they're difficult conversations to have, we would pair you with an attorney who is much more sensitive to that than someone who is very comfortable with the idea that nobody gets out alive and this is something responsible to do and we really need to get this done and just let's get it done right. That may be, it's a little bit like bedside manner, right? That might be a slightly different estate planning attorney who would fill those needs best. Okay, another question is, can I use an online service to write my will like LegalZoom? That's one of them. I think there's, I want to say another one sounds like Robot or something like that. There's several out there. That's a legal question, but I'm going to answer it from a financial perspective. Documents that have a legal function, so a will has a legal function. We've just been through all the things a will is supposed to do. And if I get that will written and I do it myself and I don't understand or I misunderstand some of the terms that are in my own will because I'm trying to get this done as inexpensively as possible or quickly before a trip or something. The challenge with all of that, and so LegalZoom and places like that might be sufficient, but I would just say be very careful because the only reason we need a will or an estate plan to begin with is for smooth execution of our wishes in our absence, right? That's the whole point. And if we haven't done that job well, then we run the risk of leaving behind not just grief, but real grief in terms of the way we've managed our estate. Now, I'm very sensitive to the idea that estate plans aren't free, and people sometimes express, well, I'll get to that when I get to it, or, is that really necessary? I don't have that much. And I would say that there are inexpensive things we can do right away, like that medical directive and powers of attorney. None of that is terribly expensive. Now, an ethical attorney is likely to suggest, for very good reasons, that you do the whole estate plan, not piecemeal. So we're the same way with planning, by the way. You can do things in isolation. tends to produce less than stellar results, which is why we push so hard to get a big picture and a complete picture. Good estate planners are going to do the same thing. However, they understand that people do need medical directives and these powers of attorney. So most of them will do something like that with the hope of you coming in and completing the rest of it at some point. The other thing that you can do that's easy and inexpensive is to just check your accounts and make sure you have beneficiaries on those. It costs you nothing but time to take the time to make sure that your accounts have beneficiaries and that they are the beneficiaries that you want. And then the last sort of more expensive thing is a detailed estate plan if it's required. But the other thing to think about is your best estate planners, the ones who think quickly, think creatively, think completely, tend to be people who don't charge the least amount of money. But what you can do is call around to the people that we have on our list and say, you know, you're recommended by our firm. We're sensitive to the fact that we don't have a lot of money allocated for this, but we appreciate its importance. So you can negotiate with them to get some smaller version of, but I just can't imagine being a parent, excuse me, and not having the guardian question answered, because what you can take care of in your absence is the health and well-being of those kids and their education. So that's an insurance. So sometimes when we go away from our financial plan, we go, yeah, she told me something about I need some insurance to cover the kids if something happens to us so their education is paid for. Then we go to our estate plan and we're trying to figure out how we pay, because right now we don't have that much money to leave the kids if something were to happen to us. Well, that insurance, and as you know, we don't sell insurance, but that insurance can be a lifesaver truly for those children if it comes after you and fills, say, a trust that's smart to have. And then let's say the children, whatever's appropriate for your family, maybe get some money at 20, 25, 30, 35. You can step that. You can also protect it from a future spouse. So your best attorneys have creative and thoughtful ways to think about these things. And while the short-term pain might be, you know, a few $1,000s or high hundreds at least for a simple will, depending on where you live, well worth the time and energy, and it's money well spent, because all we're ever doing after that is amending, fixing, noodling a little bit. Unless we move wholesale to a new state with new circumstances, then it can get a little expensive again. So let me check my Q&A again. And I don't see any other questions. We are just about 10 minutes before the hour. So I will conclude this so you can get back to your day. And I want to thank you again for joining us. And as always, if there's a topic you'd like us to talk about at next month's Poolside Chat, please do reach out to us. And we are still trying to put together before the end of the summer a real live in-person Poolside Chat. So we'll send details about that as we get it. But in the meantime, we hope these things are valuable to you and the people you care about. Remember, you have the ability to distribute these beyond you, the client. They are designed for clients and their families and extended families. So if there is someone that you'd like us to send this webinar to, just shoot us their information and we'll send it over to them and they can view it at their leisure and hopefully benefit from it. Thank you again for your time and attention.